Yeah, it's probably okay. How are you? Good to see you, Tim. Commissioner Wasserman?
Yes.
Commissioner Nguyen? Yes. Chair Remke?
Unfortunately, Commissioners Eskovich and Kasher had conflicts, so they won't be able to join us today. But we do have a quorum, so we will continue. And I'd like to start off today with reminding those who know about it and telling those who don't know about it about our exciting upcoming conference celebrating the 40th anniversary of the Political Reform Act. It is on September 17th at McGeorge School of Law. It's in the morning, I think 9 to 11. And we have 9 to 1. And we have some really exciting speakers, including Trevor Potter, who is our keynote speaker. And we'll have 3 panels, and the concept is discussing the past, present, and future of political reform. So we hope you can join us. You can register online. Free, and it is free. Is there MCLE? Yeah. And MCLE. This keeps giving me feedback there. Okay, so please do consider that. Look at it online. It gives you more information. Yeah, I don't want to keep bothering everyone with that. Part of it is historically my face. No, that's okay. All right, we'll just go from there. Hopefully you can hear me. Okay, yeah, thank you. Okay, before we get started with the agenda items, is there any public comment for any issue or item not on the agenda? Okay, seeing none, we will move on to the approval of the July 2014 committee meeting minutes. And
I move approval of the minutes.
I second.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Emke.
Yes.
The motion passes.
Okay, great. Then we're going to go ahead and move on to items 3 through 29, the consent calendar. And I'm going to start by pulling item 6 from the consent. Would any of the other commissioners like to take off any item consent, not for purposes of discussion, which we'll have that, but for other reasons?
Madam Chair?
Yes.
This is Commissioner Wasserman. May we pull item 12 for discussion and vote?
I'm sorry, 12, and did you say another one?
No, 12. Thank you.
And is that for, okay. Would the commissioners like to comment or ask questions on any of the remaining consent items?
No.
Commissioner Wasserman, anything from you?
No, Madam Chair, thank you.
Okay.
So then I would move approval.
I'm
sorry.
Yeah. Is there any public comment on the remaining items on consent? Okay.
Okay, so then I would move approval of the proposed consent calendars, items 3 through 29, with the exception of items 6 and 12.
I would second that.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Emke.
Yes.
The motion passes.
Okay, great. All right, then we will go ahead and take the 2 items that were removed, starting with item 6, which I asked to, I just want to discuss it a little bit more. I have some concerns. As those of you who have looked at it a little more closely, this matter is a CalPERS board member, and this is her 3rd enforcement action before us. She did have one in 2006, which resulted in a $6,000 fine regarding failure to file 2 campaign statements and a SEI. 2010, she was fined $3,000 for failure to file the SEI statement. And if you look back at those enforcement actions, both showed, I would interpret it to be a pretty significant failure to cooperate. The 2010 one resulted in a default after many efforts of contact. The 2006 wasn't much better. And so here we are again, and we have 4 statements that were not filed, and then they were all filed together. But as noted in the stipulation, that was after numerous requests from the enforcement unit. I guess I have a couple thoughts or concerns. Number one, the way the stip is set up is 1 violation for the 4 reports. Now I just compare that, for example, with item number 4, where there were 3 statements, 3 violations, and then 3 fines. That's one issue I have. The other issue, I feel like we may be going in the wrong direction here. We start out at a $10,000 fine, we drop to a $6,000 fine, and now we're at a $1,000 fine. And I don't know if that's the message we want to be sending for repeat offenders. And not that we have a 3-strike policy, but at this point, I think there would be a heightened awareness on her part of compliance. And I understand that in some eyes the violation is fairly minor because there was no reportable action. But I think the issue is bigger than that, and at this point I have concerns approving this stipulation. But I'll hear from anyone, or if the commissioners have any other.
Could we just ask Mr. Winnick to comment on kind of how we got to this stipulation?
Sure, thank you. Gary Winnick, Chief of the Enforcement Division. Cases like this obviously are subject to different perspectives. I think they're hard from the enforcement perspective to decide what to do with priors when you have a current violation that, absent priors probably would have warranted a warning letter. I mean, I thought for us, at least in making the recommendation, there were kind of two key factors. One, there was zero activity on any of the statements. Although CalPERS elections are obviously real elections and subject to the act, I think they're generally not perceived in the same way as other elections. That is becoming less and less true as time goes on, but there are a lot of people that run for CalPERS that don't raise any money at all and don't use sort of traditional campaign methods. So I think we tried to take that into account, try and balance out the public harm versus the prior conduct, and come up with something to present to the commission that sort of took both of those into account. I think it's obviously, as the chair aptly pointed out, subject to individual perspective on what that pass means. I guess I'd also point out she is still pending for election, so the resolution was reached before her election, which I think adds a different character also to a settlement rather than sort of stretching it out through due process past the election. Those are the factors that we considered. I completely understand the points that are being made. That was simply our perspective on something I think, absent in the past, we would have issued a warning letter, but I understand where the commission's coming from on it.
So what are our options at this point?
Obviously, you can always accept a stipulation. Absent that, you have the ability to sort of send it back. We prefer if you send it back with direction as to sort of what generally you would like to see coming back to you, and then we will go and try and renegotiate it. If not, it will go through the due process and then come back to you anyway for final decision.
Commissioner Wasserman, do you have comments or questions or thoughts on this stipulation?
Yes, Madam Chair. I understand and appreciate Mr. Winnick's position, because as we attempt to decide these individual matters, we are also signaling, what to enforcement, how we wish these things to be treated in general. I'm in agreement with the chair. This is although I have read and I understand that there was not reportable financial activity and some of the other aspects that Mr. Winnick indicated. I think it behooves us to articulate to enforcement, which way we wish to go, how we wish to treat these CalPERS elections, etc. And I'm in agreement with the chair. And I think the question would then be for me, since I will vote to send this back, is what sort of direction we can give to enforcement, with respect to what we believe are the number of counts that we think we should see, and what the penalty should be, because we haven't done that yet while I've been on it. So I just want to make sure we do it right, if we do it. But I think, given that there are 3 of us, I think 2 of us have been heard interested in sending it back. I'd like to see how does that process work for us.
Well, if there's no motion to approve the stipulation, then there could be a motion to reject and return with recommendations. I would phrase it maybe perhaps differently, or I'd take advice from either of you two, but that's how I would propose we proceed at this point. But before
I don't think it needs I'm sorry to interrupt you, go ahead.
Yeah, before we get to the voting, we'll also hear any public comment, but go ahead, I'm sorry.
I was just going to say, I think in the past where the commission has faced this situation, given me direction, there simply wasn't a vote on it, and then there was consensus on the direction, and then direction was given as to what the commission would like to see coming back, if there is consensus.
You don't have to vote to reject or return. Seems they're just pens. It remains pending out there. That seems odd to me, but I will take your advice there.
I won't oppose your vote.
You don't want to hear a vote to reject. Okay, well, we'll think about that for a moment. But is there any public comment on this item? And I'm happy to give you my thoughts and direction. At the same time, I understand it's a delicate issue, and I don't want to get in the habit of telling you how to charge and prosecute your cases, and I understand you have a much more familiar understanding of the details of everything sometimes that we don't see in the stipulations. But again, I do compare it to item 4, for example, where there were 3 statements, 3 violations, and 1,000 each. And I don't know if that's the better approach, 4 statements, 4 violations, and then a consideration. Again, my concern is, to me, this almost looks as if it were a first-time offender. 4 statements, 1 violation, $1,000. I would like to see a higher penalty, however you want to charge that or come to an agreement with it. That's my position. I'll let the other commissioners.
Well, I mean, just from my perspective, I want to bring you back what you'd like me to bring back. I think, you know, we could bring back 4 different counts at this penalty level. We could bring back 4 counts at a higher penalty level. We could bring back 1 count at a higher penalty level. And I'm happy to sort of reassess and do that and bring back if that's what you like. But if you have something specific in mind, I think that would be really helpful.
Well, I guess I would say, at a minimum, to me, the fairness and looking at some of the other items on this agenda would be 4 violations, and taking into consideration the factors you pointed out, including the no reportable action for this period. $1,000 seems understandable for that issue. So I would lean towards something like 4 violations, 1,000 each for 4,000. But I will again ask either of the commissioners if they have other thoughts.
Well, I'll just chime in. I did have a big question mark on this agenda item when I read it, and I said 4 counts, but it was charged as 1 count. It does look, I mean, reading it right after item 4, it did look like it was more than 1 count to me.
Sure.
So I do feel like it, just to be consistent, it should be 4 counts. It was 4 separate reports that were not filed. And I don't have a really strong feeling on the amount per count. So maybe you could put it in your matrix on how you charge this prior offense.
Sure.
And 4 counts, and with the mitigating, and that there was no, reportable activity, and kind of go from there.
I promise not to be cynical and drop it to Streamline. I'm just
And then, of course, I would request that any stipulation sets forth the prior to, because there was a little bit of a mistake here, dropping one of them out with the amounts, just so we can get the full picture.
Right, understood.
Commissioner Wasserman?
I think you've covered it.
Okay, so at this point, we're not taking a motion, but we are directing that it be returned to enforcement for further consideration in light of these concerns. Okay, and then we had number 12. Commissioner Wasserman, you want to start?
Sure. I think the discussion we just had with respect to the SEI filings and number of counts, etc., has some bearing here as well. Again, noting that enforcement works with what they have in terms of past commission direction, etc. So we have the opportunity to both look at the individual item 12, in the matter of Stephen Detrick, I hope I'm saying that right, and also sort of signal to enforcement how we're going to approach these things. And again, this is a matter of also a little bit of comparison going on here, looking at the difference, item 11 and item 12, just to put them in references. They are both matters where committee funds were used for purposes that other than those that directly relate to political, legislative, and governmental purposes. In 12, we have the respondent spending $93,000 approximately over the course of a year on a civil litigation involving his son. And then in 11 we had, of course, some personal purchases of one of $6,000 and one of $1,800. Those were the purchases in 11 are very easy to look at the count. When you make a purchase, there's the count, and they each get a $3,500 penalty. But in terms of proportionality, in terms of question of counts, I would look at 12 and consider that perhaps that that needs another look, because you have essentially a 3% loan for a year of $93,000 of a committee fund. And we know that at least based upon the reporting, there had to be at least 2 expenditures, because there were 2 reports filed that showed these expenditures for these legal fees. So I'm of a similar mind in this scenario as the prior discussion, which has to, I think there are more counts that should be presented here in order to get us to some sort of proportionality and fairness and efficacy in imposing these administrative penalties, where you know, an $1,800 expenditure of campaign funds for personal use gets penalized $3,500, and a $93,000 expenditure gets penalized $3,500. So there's 2 aspects to it. It's a question of counts and the extent of the penalty. There is some prior history for the respondent, but I don't think it rises to the level of what we were talking about in our discussion about the prior matter.
Yeah, and I think there's a timing issue on that to the extent it really is a, quote, true prior. I appreciate your comments. I see these two, 11 and 12, differently, and more perhaps an issue of knowledge and intent, true violation, which is really hard to even question, versus perhaps a misunderstanding. And I also want to just point out to enforcement and be careful. Obviously, stipulations are stipulated agreements, and we don't always see all the detail in some of the issues. The language and the like is obviously necessary for everyone to reach an agreement. So I know it's a little bit more complicated and easy for us to sit here and pick things apart when they are carefully worded and agreed to. So, but would you like to respond to those concerns?
Yeah, thank you, Madam Chair, and thank you for your comments. I think I echo those. They are negotiated agreements, so I think everything you say, obviously I concur with. But it is true. I mean, we do try and reach agreements. Otherwise, we have to litigate everything, and then that, you know, obviously, again, though, everything in a stipulation, to the best of our knowledge, are facts. We do allow respondents to have a say, if you will. Mm-hmm. So if it says respondent contends, that usually is giving them a chance to sort of provide their point of view. In these particular cases, I guess the only thing I'd point out, I completely appreciate the high dollar amount in number 12, and I could see where if you just sort of are comparing the dollar amounts, that doesn't make a lot of sense. But I think the chair made an excellent point in terms of the nature of the expenditure. Although in number 12, certainly that use is not permitted, I think it's much closer to being able to articulate why it might be a political, legislative, or governmental purpose than sort of buying yourself a cell phone. So the intent was really what we were looking at in terms of ascribing a penalty level. In number 12, I think we actually might have been lower on the penalty amount if not for the prior. The chair mentioned, she's correct about that, that the time periods overlap between the prior and this one. So we did take into account, but we also considered that factor as well and came up with what I thought was sort of a reasonable penalty level based on all those competing factors and negotiation, of course.
All right, thank you. Any public comment on item 12? Okay, seeing none. Sorry, go ahead.
Sure. 2 things, well, maybe 3. One is I appreciate Mr. Winnick also pointing out that certain statements in the stipulation are contentions of the respondent, because I saw in the comment letters attempt to rebut the contentions, and it's not that the FPPC is taking those statements as facts, but that the statement is the position of the respondent. So, you know, I think that the parties that are paying attention to this and have some concern that there is some finding of fact about a contention it's essentially a red herring. And I'm also quite aware from many of our other cases, and I think I indicated that I understand the sort of, for lack of a better phrase, in an administrative context, of prosecutorial discretion in presenting the number of charges and negotiating and getting things down. What I'm really saying here is that, at least in my opinion, in the attempt to give some signaling to enforcement, how I view these things, is that's how I would look at this kind of case. And while I understand, I do appreciate the distinction in the intent when someone goes and purchases pays for a family member's tuition out of campaign funds, not even ostensibly arguing that there was some sort of tuition for political committee work or something. I don't make the distinction as being so strong as to take me into sort of another category. But I do appreciate the process and what enforcement has to do. And the purpose for asking these questions and presenting my position in both is to work it out with the Commission to signal to enforcement, what our policies and our approaches are. So, thank you.
Thank you. Okay, with that, having seen no public comment request, I will move to approve item 12.
I'll second.
Commissioner Wasserman?
No.
Commissioner Wynn?
Yes.
Chair Remke?
Yes.
This motion passes. Motion fails.
That's right. So Mr. Winnick can bring it back at another meeting with.
How does it fail at 2-1?
Oh, I'm sorry. Yeah.
I was questioning my math skills again.
The motion passes.
Motion passes.
Okay,
I'm sorry.
thank you.
Long.
We will move to item 30, which is the approval of campaign form T10, representing the top 10 contributor list that we are now putting together.
Absolutely. Good morning, Commissioners. Linda Cassidy with the Technical Assistance Division. Before you today are two items. First, as the Chair mentioned, is our new form, Campaign Form T10. This will be the form that ballot measure committees and candidate committees on the state level who have raised $1 million will file with the FPPC a listing of their top 10 contributors. As you can see, we've tried to make the form very simple and basic and user-friendly. The form just requires some basic information on the committee, then their list, and when things change, they'll mark a box and notify us. The other information, it relates to the campaign forms themselves and the new rules affecting multi-purpose committees and their disclosure requirements. As I mentioned, I had a public meeting and we incorporated some of the comments, technical in manner, and since this was released 10 days ago, I haven't had any additional comments. So I ask for your approval. Jen?
Go ahead.
Yeah, so I thought you did a really nice job. This is really simple. You know, it's
thank
one
you.
of those things that could have gotten really gummed up, and it's just really simple and straightforward. My question is just relating to the public process. So did nonprofits come to the table? Did they, was the conversation robust? And, was there kind of consensus, or was it all over the place and staff just kind of had to buckle down and get it done?
Basically, we had we had almost no comments from a single multi-purpose organization. Our comments were basically from political treasurers and attorneys and the Secretary of State. So I think what will happen is once this really becomes effective, we will begin to receiving email requests and so forth, and we'll be working with the multi-purpose. So I won't be surprised if I'm back here next year with changes and more information based on when people actually start to complete the forms, right?
And when are the forms first due? Can you remind me?
Yes, I believe it's September 5th for any committee that has raised $1 million, the two
And
tens,
what's our optimistic hope for when we'll have this stuff posted?
on the following Monday. We've
Okay.
done an internal look at the Secretary of State's website, and it appears there might be only 4 or 5 committees that have already reached the $1 million. So we assume we could probably process those quickly and post either Monday or Tuesday.
Great. Thank you. Is there any public comment on item 30 regarding the Form T10? Okay. Seeing none, I move to approve the new form.
I'll
I'll
second.
second that.
Oh.
This is Commissioner Wasserman.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
Zach Marzini asks to talk about item 12.
Yeah, Madam Chair, may I bring up item number 12? Our regulations at section 18327 specify that except as otherwise provided by regulation, the concurring votes of at least 3 commissioners shall be required to authorize any formal action by the commission. That's why I initially said the matter did not pass. So when it's a quorum, the vote needs to be unanimous on that. So item 12 has not
That's the
passed.
oddest rule or regulation I've ever heard.
It precedes my arrival at the commission.
That doesn't even really make sense. Okay, so we'll have to go back and
So the
clarify.
legal effect, you can either take another vote on the matter, but I don't think that would help. But at this point, Garrett, the chief enforcement, can choose to bring the item back at another meeting and have another vote on it. So the matter did not fail, it just did not pass. So he can bring it back, and when there's a full commission, we can vote on it again when there's 4 commissioners, and see if you can garner support then.
Gary Wenke again, Chief of Enforcement. I'm back. I guess we'd ask, that it be brought back for the next hearing, absent a third vote.
Okay, that is what we'll do. We'll put it over and bring it back for the next hearing. And we'll also look into that odd quorum ruling in the meantime. A quorum means a quorum. I don't know. Okay. Did you hear all that, Commissioner Wasserman?
Oh, yeah, yes, I did. And I appreciate that it will be brought back. And I think I begin to understand why we have that odd rule. But, hey, we are an entity, we are sui generis.
Okay.
Oh, man, did I use Latin? I'm sorry.
That's not allowed.
Yeah, I will. We'll put that in a commission policy.
Okay. We'll move on to the executive staff reports, item 31. And Ms. Peth, I believe you wanted to start with a comment, a thought?
Yes, we can submit the staff reports unless any of the commissioners have questions, but I wanted to take a minute to recognize Dixie Howard, who is retiring from the commission this month. Ms. Howard has worked for the commission for 24 years, most recently as the Assistant Division Chief for the Technical Assistance Division. During her tenure with the commission, she was influential in shaping the educational programs the commission offers, and she's recognized throughout the state as an expert in the Political Reform Act. And I think you will hear universally disappointment that she is leaving us. Staff estimates that she has provided guidance to over 50,000 people during her career, and she has been an outstanding member of our staff, and she will be greatly missed. So on behalf of the commission and the FPPC staff, I would thank her for her service and wish her the best of luck in her retirement.
I concur, and Dixie's in the audience. Thank you very much. She will be missed. Do the commissioners have any other questions or comments about the reports?
Thanks.
Madam Chair, I just wanted to say one other thing to Ms.
Okay,
Ms.
go ahead,
Howard.
Commissioner Wasserman.
Just to Ms. Howard, when I was doing my outreach and talking to different filing officers and entities, exactly the sentiments that Ms. Pett articulated were repeated uniformly. Great respect for Ms. Howard, and I'm absolutely sure she will be missed. Enjoy your retirement.
Thank you.
Great.
Commissioner
That's all.
Wynn?
Thank you. I also want to congratulate you Nice job, and thanks for your service. And I do have a question just on legislation. So I heard on the radio yesterday that 3 bills passed that had to do with the Political Reform Act, and I was just hoping maybe you'd give us an update, because I know it was not reflected in our binder, because we got our binder 10 days ago.
Passed but not signed.
Yes.
Okay.
So none of them have been signed by
See,
the
we
governor
missed
yet.
that intrigue. That's the stuff we missed, just with the paper. So thanks. Yeah.
Okay. Well, did you want to know which one's passed still out of the legislature at least?
Yeah.
So AB 1431 has passed and is on its way to the governor. AB 1716 has passed and is on its way to the governor. AB 1728, AB 2320. Am I going too fast?
No.
Okay.
That's good. Thank you.
AB 2692, and that's it.
Okay. So I know that we were providing technical assistance, but in the last minute kind of flurry of activity, have you been over in the Capitol, continuing to provide technical assistance? And is there anything that pushes us from merely, providing technical assistance to wanting us to take a position?
Well, one thing to note is that under the Act, the Political Reform Act bills have to be in final form 12 days before they're voted on. So that period has already passed for our bills, at least. So that's with these bills as they sit, the language, will either obviously be voted up or down and signed by the governor or not. But at least the language has stopped moving.
Okay.
And there's a couple bills that we're still really working to just to decide how strong of a position we should be taking, given now that we've had the final language.
I'll just go ahead and point out SB 52 so that there's no surprise as far as my position, which may not be very popular, but as those people following that bill, it has been amended, and even as late as August 12th, I think was the last set of amendments. And so it's been hard to stay on top of it. But I think in its current form, there are several very serious concerns with the bill from our implementation concerns. So we're just going to continue to talk with the author's office and make sure that the legislature understands some of those concerns which staff has expressed, and we haven't kept it a secret over there, including the high cost of implementation. There's issues with whether or not portions will be construed as unconstitutional. There's certainly strong issues of vagueness on the bill and how to even implement it. So I'll just throw that out there so there is no surprise, at least from if people start to hear our concerns. Go ahead.
Well, so thank you so much, Madam Chair. That's exactly what I was hoping we were at least involved in, because when we go through the legislative report every month, we just kind of go through it quickly, and we are the experts, and I'm sure the legislature would be appreciative of the fact that we are really in there saying this is too vague, this is too expensive, So anyway, I'm very pleased to hear that. So thank you for letting us know that.
Yeah, we've been working quite a lot, especially this year, since there's been so many bills. I mean, there's still already 16 or remaining 16 bills that would amend the act. So it's been a very, very active legislative year for us. And
I understand that we didn't want to take positions on everything, and I understand that there have been a lot of moving parts which would prevent us from doing that. So, here we are, August. We don't have positions on very many bills, which is fine with me. I early on thought we should have positions on bills and we should go in and really negotiate. So I'm more appreciative now of kind of staying back, but as long as we are continuing to share our expertise with the legislators who are really trying to make a difference in this law, then I'm very happy.
Yeah, absolutely. It's not as if we're sitting silent. And, unfortunately, just the timing with when I came on board and how far along in the process we already were, to some extent, we didn't see, excuse me, is it fair jumping in so late in the game? But we've always been open and sharing concerns about implementation with the author's offices.
Great. Thanks.
Commissioner Wasserman, do you have any comments regarding the reports?
No, and I think that I think the discussion about SB 52 and laying that out ahead of time and the work that's being done is the right thing. Great job.
Okay. I would just like to take a minute to highlight one of the advice letters in the Legal Division's monthly report. It's on page 4, and it's A14148, Betty Ann Downing. The advice letter deals with the restrictions on any candidate who elects to make independent expenditures. This is following the Superior Court's recent decision in the litigation with Chuck Reed versus the FPPC. That was listed on last month's agenda, and there was a brief discussion in closed session. I just want to highlight it to the extent you have not read the advice letter and or the Superior Court's decision. The advice letter will be available online. I encourage you to read it. And it also has a citation to the Superior Court decision, which you can also turn to. Okay? Anything else? Okay, unless there are any other questions, I move to adjourn this meeting. Is there a second?
I'll second that.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes. Okay, thank you.
Thank you very much.
Thanks.
Have a good day.
Turn all the lights.
And so I can take these back to gospel and staff.
Let me send this. Let me send you the